Welcome to Money Matters with Greg, where we dive into the money conversations shaping your life. From investments to estate planning, insurance to taxes, we cover it all with a fresh perspective. Join Greg and his guests each week to get inspired and take control of your financial future. Let's get started. Securities and investment advisory services offered through LPL Financial, a registered investment advisor. Member FINRA SIPC.
All right, good afternoon. The show's Money Matters with Greg. I'm Greg Farrell, CEO and owner of Farrell Wealth. It's a wealth management firm locally here in Valparaiso, Indiana, and helping clients in now 24 states. You can find us at WVLP 103.1 FM on Thursdays, and then replayed on Saturdays at 1 o'clock as well. And then anywhere you pod. The show talks about money as you follow, and with now the 175th episode, which will be today. We talk about money, trying to save you money and help you out and your family, add some value to your life with your investments, with your estate plan. We did real estate just last week. So we're going to talk estate planning today. And we are very excited to have Tyler Gluth from Marks & Lucas here locally in town to be a part of our podcast today and ultimately our video. You can find us on YouTube. You can find us anywhere you pod as well. And we're going to talk just let Tyler kind of talk about things that he would recommend to help you out there with your wills, your trust, your probate, you name it. There are many things we know that are much lengthier topics than just a 20-minute pod, but we wanted to get to something here to kind of add some value. So Tyler, thanks for being here.
Yeah, thanks for inviting me, Greg. I appreciate it. Estate planning is a really broad topic, and usually it's pretty intimidating. Sometimes can be intimidating to some people and kind of confusing because a lot of people may not understand or know completely what it encompasses.
Yeah. What we find is, I see 80 to 90% of the people that I meet just in general, and this isn't necessarily clients or high net worth clients, but most people don't even have a will. They don't have a medical power of attorney. So, where can you start with that?
Yeah, I would tend to agree with you. A lot of people don't have an estate plan, and the problem is when they realize they need one or should have one, it's oftentimes too late. So, a good starting point is in the interest of, theoretically saving yourself money or, being cost effective with your resources is, getting an estate plan and getting a good one that encompasses not only a will or a trust, but also a financial or healthcare power of attorney. The benefits to an estate plan, a lot of people say, well, why do I need one? I'll be dead. And the reality is, yeah, you will have passed. It'll make your life much easier, or I should say your beneficiaries' lives are much easier if you have your wishes detailed. But also, most importantly, is getting those powers of attorney executed during your lifetime while you have capacity. Because again, if you wait till it's too long or too late and you're incapacitated, well, then your family has to more often than not open a guardianship to assist you with things, and that's incredibly expensive. So a good starting point is to find yourself a good advisor, to get yourself a good estate plan. And that is the starting point, just taking action, learning what your options are. And, again, that's a whole different pipeline of topics. But more often than not, most people just need a will with their powers of attorney, and you get those executed. And a good attorney should be able to walk you through not only what your wishes are, but the impact that those wishes will have on your estate after you've passed, and how your assets will flow or pass to your beneficiaries. And there's things and mechanisms that we do and that you use in your industry as well to help that happen.
Sure. And most people don't even realize that just the beneficiaries on an IRA or tax deferred is, it all trumps wills. And it's so easy and it's free. It's an easy way to be able to make sure that you give a percentage to a charity. You can give part of your IRA that way, in a very easy way. You don't have to go through a long process to do that. But if one is wanting to categorize, itemize, inventory their estate as to where things go, what's the one thing that you would, I mean, you suggest? Obviously, last will and testament.
Yeah. So we get clients that obviously want to leave specific items or specific assets to beneficiaries.
Yeah.
And that's a pretty easy thing to screw up. If you think you're kind of going to do it on your own and, hey, I'm going to write a letter to my children and tuck in an envelope and they're going to know what to do with, all of my guns or jewelry or, oftentimes it's always something like plates, dishware, what have you. But again, that's really important because you have to meet with an attorney or should. And there's a statute that covers that where you have to specifically identify the item, you have to describe it, and you have to detail where you want it to go. And we incorporate that into your estate plan. And again, when your estate gets probated, we ensure, or whoever represents your personal representative will ensure that all those assets get to where you wanted them to go. So it's very important that you have a skilled professional to assist you with that because, again, what we find is people write it on the back of a napkin or something like that, and that's just not legally enforceable.
Yeah. One of the things we always find is that, asking your best friend or your brother, or your sister, or whomever that you trust to be executor of the estate always seems like a very flattering, honorable offering. But we all know it sucks.
It is not a fun job.
It's not something you give to someone. I honestly, if you liked them, you probably shouldn't give them the job. So it's a ton of work. It's a lot of work. It's a fiduciary responsibility that you aren't necessarily aware of as well to make sure that everything goes the right way. So let me ask you this. If there's, as far as cost involved, that's the cheapest free version, right? To have an executor that's a family member run the estate. But like, if you don't want to do that, where can you go? And then what kind of cost would be entailed with some of those things as far as like trustees?
Yeah. So I would say more often than not, most people select a relative, a sibling to serve as their executor or their personal representative. And I say those terms they're ultimately interchangeable. Trustee is slightly different. It's ultimately the executor of your trust, so to speak. And like I said, most people pick relatives or family members. However, we also have clients that know that sometimes there are potential conflicts of interest, especially when your executor or trustee is a beneficiary. And so sometimes that presents challenges, or there's just family dynamics that sometimes present challenges. So in those instances, a lot of our clients will seek a corporate fiduciary to serve as the trustee or personal representative in that capacity. And the benefit to that is theoretically, it's a neutral party that doesn't have any skin in the game. And obviously has knowledge on how to handle these things, especially in relation to financial accounts. And there are fees associated with that, right? Because it's a professional practice or professional service that they're offering. The fees, in my experience, range dramatically depending on what institution you go with, but usually they take a percentage of the assets under management. It can fluctuate, and Greg, you could probably touch a little bit more on that. But usually it's tiered too at a lot of places, right? Based on the amount of funds that are under management or the value of the assets under management. But I've seen it about 1% or 1.25%, and usually there's a flat fee associated with it as well. And sometimes there's hourly rates associated with it.
Yeah, it can go into the thousands, if not tens of thousands, if you're not.
Oh yeah, I mean it is the most expensive way, I would say, using a corporate fiduciary to administer your trust, but theoretically, more often than not, eliminates a lot of the conflict.
Yeah, we have so with our broker dealer, they bought a massive trust company for that reason, because they would lose, assets overall would go to banks that would be named. And then the advisor would lost their whole relationship with the family. So they went out and bought PTC, which is called Private Trust Corporation. And they could be named in a will or a trust or whatever. So we can actually continue to work with the family, which is great. And we see those fees be, everywhere $3,500 to $6,000, somewhere in there ish, as a flat fee to come in and be the trustee, and especially in a divide like a, many of our clients have second marriages, and they have different kids, and they want their three, Brady Bunch situation where three kids, from a previous marriage want to make sure that they're good, three kids want to make sure that they're good, and a trustee can do that.
Oh yeah, I trust, and the way the federal inheritance tax threshold is situated now, it's not so much of a concern for a lot of our people here in general, right? Per se. The reality is most people don't accumulate that level of wealth in their lifetime.
Yeah,
But
and
some
so
obviously
I know what it is, but I want the audience to know. So what is the exemption overall?
rough ballpark, I want to say per individual, it's like $15 million.
It's going to 15. Yeah, it's going to 15. It's 13.9-ish right now. So
it's obviously relatively high, and very few people attain that. And so, trusts have their purpose. I tell people a trust functions as a hub, right? During your lifetime, you put everything in the hub. You may die, but during your life, you're in control of the hub. But when you die, you're gone, but the hub remains. And your successor trustee just comes right back in, fills your shoes, and then drives the bus, controlling the hub, so to speak.
Okay. Great analogy.
The benefit to that is, if done correctly, can avoid probate. The cons to trust are it's incumbent on you for your whole life to ensure that everything makes its way into that hub. And if you forget something, well, then you have to probate that asset and administer a trust. So you have two administrations when you should only have one. But trusts absolutely serve their purpose. A subsequent spouse scenario, like you said, Greg, or a blended family. Or the more common thing that we see are people that snowbird in Florida or have a cabin in Michigan, and you don't want to have to probate two estates in two different states. So the benefit to trust is the trust holds the real estate.
Yeah, and we always make sure that when people establish a trust, they understand the fact that basically they as an individual disappear.
Yeah. 100%.
Suddenly they're wiped off the face of the earth.
Yeah.
And now their trust is, they are the trustee, they are the owner of that trust, of course, whatnot. But the trust now exists. So you have to really think like that with everything you do in life.
Everything.
Which is really important to everyone. So first of all, just real quick station identification. The show's Money Matters with Greg. I'm Greg Farrell, CEO and owner of Farrell Wealth. It's a show about money. We talk here on 103.1 FM WVLP on Thursdays at 1 o'clock and Saturdays replayed at 1. And then we also you can find us anywhere we pod. Our YouTube channel at Farrell Wealth is all of our socials. You can find us there as well. We're talking with Tyler Gluth here from Martin Lucas, here's local downtown in Valparaiso, Indiana, talking estate planning today. Tyler, just a real simple question. What are the three things that everyone really should have in regards to estate plan? Just simple, basic paper.
Well, I would say first and foremost is to have an estate plan in general. Taking that initiative, just getting to that spot sometimes is difficult for people. And I don't blame them because having to think about death at any point during your lifetime is sometimes pretty difficult. But it's a reality, similar to taxes, right? No one gets to avoid those, or they shouldn't. And then the other two things that I think are hugely, hugely crucial, and oftentimes probably more important than the estate plan itself, whether it be a will or trust, is having a financial power of attorney and a healthcare power of attorney. Because you would hate to be in a scenario where unfortunately you have a stroke or, you're incapacitated in the long term, and you don't have anyone that can make those difficult healthcare decisions for you, and you're just relying on a really sweet physician, being kind to understand the situation. So having those three documents, whether it be a will or a trust, financial power of attorney, healthcare power of attorney, are the three most important things you can have.
And the financial power of attorney, just to thank you for that. The financial power of attorney is really who's going to pay my rent or my mortgage or my credit card bill and my electricity bill while I'm incapacitated in the hospital, right? It's not like you're giving them power to do other things with your finances.
So there are obviously different types of financial powers of attorney, but we at Martin Lucas write springing powers of attorney, meaning they go into effect upon your incapacity. And you're right. They have power and authority under the statute. They have to function in your interest. They're a fiduciary, like you referenced prior.
Right.
They basically, if upon your incapacity, would run all your business and financial affairs. They pay your utilities, your rent, your mortgage, things of that nature. But they have to adhere to the law and function in your best interest.
Okay. So follow along. It's not like you have to be incapacitated before it springs into life, in essence, right?
Correct. I mean, you could just grant someone power of attorney, today to function in that capacity for you. Oftentimes, I don't like that because we do see financial abuse,
Right.
Especially with elderly individuals, but we see it with younger folks too.
Yeah.
So that's why, again, I write them to spring into effect upon incapacity. Because at the end of the day, theoretically, that's more often than not when you really need it. And incapacity in Indiana doesn't necessarily mean that, you're in a coma or something to that effect. It could be something as simple as you had a surgery and you're homebound.
Yeah. Well done. Thank you. The other question I had was probate. So like most people don't realize probate's come a long way in 20, 30 years, at least in my career. I mean, everyone's like, but it is better. But it is timely. It is expensive. Any idea on the range of costs to have to run things? If you do have a bunch of things that need to go through probate in the state of Indiana and then beyond.
So that's a difficult question because obviously every scenario is different, but the things that do impact the price or cost of your probate estate are how many assets do you have to probate? And again, with modern banking, I should back up. Probate just means the legal mechanism to get your things from point A to point B when they cannot automatically transfer upon your death.
Okay.
And so examples of non-probate assets are anything that's jointly owned as true joint tenants or joint owners, or any asset that has a beneficiary tagged on it. Good example, life insurance, non-probate. Home that's owned as husband and wife, non-probate, just goes to the surviving spouse. An asset that is oftentimes probatable is a car that's only titled in one spouse's name, or a bank account that's titled in only one spouse's name. So probate is a fairly long process, can be costly. The range of cost really depends on, again, the number or amount of assets that have to get addressed. But the biggest driver oftentimes is conflict. If everyone plays well together and gets along, oftentimes they're not too bad. But if you get to fighting and there are disagreements, which oftentimes there is because there's a lot of emotion involved.
Families disagree? Are you kidding?
Yeah, they tend to. Well, you throw death and money into the mix, it oftentimes plays games with people's psyche, and we see that a lot.
Yeah.
And the one thing that we do here that I appreciate a lot, and I think a lot of attorneys in Northwest Indiana try to do or should do, is try to keep a lid on conflict. The more often, everyone says, well, lawyers like to argue. I would disagree with that. I mean, obviously there's some that do, but I see a vast majority of us now, like you said, probate's come a long way. We're problem solvers, right? We see all the potential hiccups and we see all the little rumblings amongst families. And again, if we can keep a lid on it and just get you to the end of the tunnel, it's really not too bad. And I'm sorry, it doesn't necessarily answer your question because it is a wide range, and it is more expensive now than what it was pre-COVID. But there's factors.
Why is that?
Well, costs in general everywhere have gone up, and so the costs in the legal profession have gone up. But the other thing that we see too is, again, I don't know if it's society or if it's culture or things like that. We find people fighting about a lot of things. And again, if you have a very detailed and good estate plan that you've done with, a skilled professional, it eliminates a lot of those problems, or, I won't say eliminate, but can minimize the impact.
Can minimize for sure. Okay, very, very cool. We're talking about Tyler Gluth here from Marks & Lucas, estate planning attorney, and a number of other things that their practice does. One of the things that I want to make sure the audience knows how to get a hold of you. So where's the best way to find you?
Sure. You can call us here at Marks & Lucas. We're at 105 Lincoln Way, downtown Valparaiso. We're right across the street from Blackbird Cafe. We've been here for about 10 years now. You can always give us a call at the office. Our phone number is 219-462-1529. Or if you have any questions or concerns or thoughts, you can always email me at tgluth@martsandlucas.com.
Awesome. And that's Marts with a Z, right?
Correct.
Yeah.
Yep. And totally spelled out.
Exactly. Well done. Anything else you want to leave with leave the audience with here as we kind of close up?
No, I think we've touched on a lot of basic concepts of estate planning. Again, it is a pretty broad range, and
Pretty broad range.
the thing about it is it's not always a one size fits all, and it's one of those things that you just have to take the initiative to do it, and then when you do it, the peace of mind that you get after the fact, I think takes a weight off of a lot of people's shoulders.
Yeah, maybe we can do another episode where we start talking about the sophisticated stuff with the family trust and the clats and the cruts and all the other stuff that goes on in life.
All the junk that accompanies it. Yes.
That's a whole other conversation for everybody out there, but it does exist. And I do see a need for it, especially with the families that we work with and when they have millions of dollars of assets and many different properties in different states. And it's just, it's necessary. It really is. So, and again, as my dad always taught me, and I run the whole business after this premise, is make a plan, work the plan. And if you don't have an estate plan, it's really tough to work the plan for your successors and your heirs and your beneficiaries.
It's definitely difficult, and without one, I can't tell you. I could write a book on the number of horror stories we've seen or really sad scenarios. Because again, if you don't have one, the state of Indiana and almost every other state, I'm sure, in the United States has a statute that theoretically covers your bases called intestacy.
Yep.
And what they do,
and they're happy to give it to you too.
Yeah, our wonderful lawmakers have thought that they have covered everyone's bases, but the problem is when you die intestate, oftentimes your assets go to places you don't necessarily want them to go.
Right.
And sometimes that's really difficult news to give to a family. In fact, we just had to do it yesterday. It's challenging. So I can't stress enough the importance, again, of having an estate plan, but also truly an emphasis on those powers of attorney, because you would hate to have someone have to open a guardianship for you. And you want to talk about cost ineffectiveness. A guardianship administration is one of those.
Okay. Thank you so much. Thanks for being on, Tyler. Really, really appreciate it.
Thanks for having me.
Yeah, and have a great holiday. We'll see everybody. See everybody later. We'll see you.
Thanks.
Thanks for tuning in to Money Matters with Greg. We hope you gained some valuable insights today. Remember, your financial journey is personal, but you don't have to go it alone. If you enjoyed the show, be sure to subscribe and share. Until next time, here's to making your money work for you. Securities and investment advisory services offered through LPL Financial, a registered investment advisor. Member FINRA SIPC.